Good morning, folks. Welcome back to another Settles. My name is Pico Conway, and today we're going to discuss two cases. And this has to do with the use of force. The use of force in correctional institution. If you work in a correctional institution, you know the likelihood of using force to gain compliance is always there. So as a correctional officer, CO, you have to know when and how to use force. That is why in most correctional institutions, there is annual training to help officers understand when and how to use force. There's a use of force manual that most people have to know, so that you know what are the guys are active resistors, passive resistors, and the different levels of resistance that those inmates put up against correctional officer. So as I said, in some instances, you have to use force to gain compliance. And in the process, people get hurt. Either inmates get hurt or officers get hurt. So it goes both ways. So today we're going to discuss two cases. First, let's discuss the case of Johnson versus Glake. And this case happened in 1973 in New York, Rikers Island. The case happened in 1973 in Rikers Island, New York. In 1973, a man named Raymond Glake, right? The Raymond Johnson. Then a pretrial detainee, as I already stated, filed a lawsuit against the correctional officer named Glake, G-L-I-C-K, Glake. Johnson alleged that Glake assaulted him with cause or provocation. There wasn't just a simple assault claim. It raises a significant constitutional question. Did the action of a state correctional officer, even against someone not yet convicted of a crime, amount to a violation of that person's civil right? So, as a correctional officer, you have to use your force when it's necessary. In this case, Johnson alleged that Glake assaulted him without any provocation. So, he brought a case. This case is, if you want to read the case is U.S. He brought a case. Johnson brought his case against the officer, and the legal ground on which he was bringing the case was under USC Section 1983. And I will have to read what Section 1983 said. Section 1983 of the USC Section 1983 says, the Section 1983 is a powerful federal statute that allows individuals to sue state actors for violation of their constitutional or federally protected rights. It reads in part that any person acting under color of state law who deprives another of constitutional rights can be held liable in the court of law. That's why Johnson brought a suit under. He brought a suit under USC 1983. So those are all who work for the state. People can sue you for your actions. So if I should assault an inmate for no justifiable reason, that inmate can bring a lawsuit against me under USC Section 1983. There are other things that have to happen that happens in federal court. USC Section 1983, you have to take, that is the federal law. You got to take that case into federal court. But before you can take a case to federal court, you got to exhaust all of the remedies in the state court before you can go to federal court. What do I mean by you have to exhaust all of the remedy? The inmate has to first file a grievance process within the institution. The institution has to investigate the incident. If the inmate is not satisfied with all of the process within the institution, then he has to take his case to the state court. And when he's not satisfied with the state code. There are other nuances and other things that have to be certified for him to. Then he can take his case now to the federal court and bring this case under USC section 1983, which states that any person acting under color of state law that violates another person's constitutional right, that person can be liable in the court of law. So the U.S. Appeals Court for the Second Circuit agreed to hear the case, and they hear the case, right? Johnson used this statute to take the case to the federal court. He will claim that Officer Glick's actions violated his rights under the 14th Amendment, which guaranteed due process of law. Because Johnson was a pretrial detainee and not a convicted inmate, his claim could not fall under the Eighth Amendment prohibition on cruel and unusual punishment. Instead, he had to be assessed under the due process clause. So you got to know the distinction now. The pre-trial guys can bring his charge on the 14th Amendment, not under the 8th Amendment. So Johnson brought a case against Blake. So when the court heard this case, the court gave 4 principles or 4 reasons on which you can use force. Firstly, when you're using force, was the need for the application of force? Was there a need for the application of force? Did the officer need to use force in that instant? That's why you got to be very, very careful. In my own experience, that's an incident. Let me not deviate a lot, but in my own experience, there was an incident that happened a few months back where I was doing what we call security check, and they try to check and see whether everybody's okay. Because as a correctional officer, that's your sole responsibility, is to ensure that all the inmates, in your custody or under your supervision are safe. So this day I was doing security check. It was 8 o'clock in the morning. I saw it in the morning about around 8 o'clock, 8 a.m. Try to do, that's not 8 a.m., around 7:30, try to do my security check. And I got to this cell, this gentleman, not doing security, I'm doing what we call bars and windows. Bars and windows is where the officer had to go in the cell and, check to see whether the windows and bars, nothing is tampered with, see whether there is nothing in the cell unusual. So when I get in this particular cell, the inmate said, his cellie was, wanted to fight him and stuff like that. So I asked his cellie, I said, what's going on? He said, nothing's going on. He just, he's an old guy, and his inmate give his, the other guy, his cellie give his side of the story. So I told the German, I said, look, we just come in. He said, he's nothing happening. So if we're not finished doing my bars or windows, and you guys come out for rec, I will look into your situation and see whether we can try to move you out of the cell so that you guys can get any further confrontation. So when I got out of the cell, tried to close the door, the guy who complained to me put his foot to the door, prevented me from closing the door. In that instant, I could have used force, take my silver red and spray the inmate. But I look at the totality of the incident. You have to look at the totality of the incident. I told the guy, verbal, give him 2-3 verbal redirection. Step back, close the door, shut the door, and I move on. So was there a need for the application of force? That's one of the things you got to look at. Was there a need? In that instant, was a need application of force. But sometimes you got to use what we call our RPC skills, to de-escalate situation for you to not get to that level. I'm not trying to say anything against Officer Glick. That's not what I'm saying. Because most of the time, the incidents that happen in prison world, they are split-second decisions that you have to make in some situations. Split-second decisions that you got to make in some situations. So I don't want to criticize anybody when they use force. I'm just trying to tell you that what the court said, that was one of the things. The second thing the court said was, what was the relationship between the need and the force used? The thirdly, the court said, what was the extent of the injury inflicted? And 4, Was the force applied in good faith to restore discipline, or was it maliciously intended to cause harm? So these are the things you got to look at. I know when we go to our training for the use of force, we discuss it, but you got to look at it. Was the force used maliciously, or was it intended to cause harm? So when the court looked into the case, they found that Officer Glegg's action went too far, and so Officer Glegg was found liable for the injury that Johnson sustained. You have to understand that this case, this guy didn't sustain any significant injuries. But in this case, they were not looking at the injury that was caused, but they're looking at the reason the force was used. That's why I say you got to always be careful, mindful when you're using force. You got to look at the totality. That's in Woodley versus Arbor. You got to look at the totality of the situation that you're dealing with when you're using force. So in the case, the standard use was what they call deliberate indifference. You know that this particular action is going to cause harm to the inmate, and then instead you use it. That was earlier. But then that case, that deliberate indifference case, let's say criteria didn't apply in the next case that we're going to discuss, which has to do with Woodley versus Alberts. That has to do with case. Basically, Woodley versus Albert, 475 USC 312, 1988. That was the time that this case happened in 1988. And Albert brought this case against Officer Woodley because he felt that Officer Woodley shot him when he posed no significant threat. And this case happened during a riot situation, a hostile situation where prison officials were trying to restore order, and Officer Woodley shot Alberts in the process. Albert survived, but then Albert filed a lawsuit against Woodley and other prison officials, claiming that they were deliberately indifferent. So you got to understand, in Johnson versus Glegg, the deliberate indifference was used, right? That was a lower standard that was used. And according to the background of that case, there was no provocation. Johnson was attacked or assaulted by the officer, according to him, for no justifiable reason. And he won that case. But in the case of Woodley versus Alberts, this was a riot situation going on. And the lower court wanted to apply the same deliberate indifference standard in this case. But the Supreme Court said, no, you can't use that standard in this case because there was a riot situation in which prison officials were using force to restore order, not to hurt any inmate in particular. So you can see the difference there. And you got to understand, you can use excessive force, but it got to be within the context. The context got to be really, really necessary for you to use force. And in the other instance where you use minimal force, and this guy had a minor injury, I don't know how minor the injury that Johnson sustained when Glegg assaulted him. I don't know the extent of that injury. But the point I'm trying to make here is that you as the officer has to understand that if you are using force, you must use the force in the way that is necessary. That is necessary. Because if not, you're going to be jammed up. So when you see an inmate doing something, you do something, you have to understand that. Yeah. So let's just look at Whitler a little bit. Let's just look at Whitler a little bit. The central constitutional issue was whether the shooting of inmate Albers by a prison official during the prison riot violated the Eighth Amendment. Okay, Albers argued that he was shot unnecessarily and maliciously while he posed no threat, which constituted a cruel and unusual punishment. Now, as I said to you, a convicted inmate had to bring a case under the Eighth Amendment. But then a pre-trial detainee who was assaulted had to bring a case under the due process. So you have to understand the two things. Under the due process is, I'm not being convicted or anything. Why should I be treated like this? I'm not saying that pre-trial detainees who engage in bellicose activities, violent incidents in prison cannot be handled the way. But I'm saying that they are treated differently because they are not being convicted of any crime. You know? But in a situation where this guy was shot and survived, but the officer was not found liable. The officer was not found liable because his use of force was justified. So I hope I explained these two cases so that when you're using force, you will understand when and how to use force. You will also be aware of your own institutional use of force policies. But I encourage you to read the laws related to these use of force policies. Because if you don't understand them, if you don't read these cases for yourself, you're going to get jammed up. And let me say this, where I work, my institution is against officers using force unnecessarily. And I know most institutions, most facilities around the countries do. They protect the officers, but they always caution the officer to use force as the last resort. As the last resort. Because there are a lot of not a lot, but many cases, if you read cases, most of the cases are about, illegal use of force, excessive force use. Inmates bringing cases against the department, against officers for violating their constitutional rights. So I think it's necessary as officers for us to understand that the case of Whitley, if you read the case, you understand that they used force, why they used force, and what was the perimeter, what was the situation, and you can put that in your own situation. In the case of Johnson versus Clegg, you can also put yourself in the similar situation and see why that case, in that particular case, the officer came on the losing side. As I already said, I'm not here to judge officers' action because most of the times the decisions we made in prison walls is just split-second decision. A few days ago, we have to respond to a code one where the inmates were involved in a physical altercation with an officer. And we have to go there and restore order. So the use of force in jail is there, but so you have to understand how to use force and understand your use of force policy or manual, and also read the laws related to use of force. If you know the laws, you always have yourself relaxed and you use force when necessary. I know it's easier for most autos and second guess people after the incident is over, but my thing here is I want us as officers to read not just policies but laws related to the policies. So by reading the law, you understand the context. You understand the context in which the particular situation happened. Like we're talking about The case of Johnson, of a pretrial detainee, and the case of Albert, where there was a riot, prison riot, hostile situation. So you see, if you look at the two cases, and you just put these two cases in your mind, your use of force policy, why it might not be the exact same thing, you will use force when force is necessary. When force is necessary. You will not just use force because you want to use force. You will not want to spray a guy who is moving away from the situation. Or you will not want to, strike an inmate who poses no threat to you when you have no justifiable reason for doing that. So knowing these cases, understanding the context, understanding what the criteria is, as I said, when you're using force, was the force intended to restore order? Or was the force used maliciously to cause harm? These are the things you got to understand. Are you using force on this inmate just to cause harm, or are you using the force to restore order, to gain compliance? As I said, there was an inmate a few days ago who didn't want to comply with the officer, actively resisting the officer, and we have to go in there and help him understand that he has to follow the directives of the officer. So as some people think, officers are not in the business. Most officers are not in the business of going to harm inmates. Being a correctional officer is a dangerous job. So I don't think there are any of correctional officers who go into work and say, I'm going to work today to go and beat up inmates, because that alone put you in harm's way. And our bosses, our supervisors, always caution us to be careful when you go to work. One of the big things they say, we want you to go home to your family the same way you came in here. You don't want to call somebody's husband or somebody's wife, somebody's brother and loved one to say, oh, your husband or your wife is in the hospital. He had been assaulted, brutally attacked by an inmate. So you have to always make sure you are aware of your surrounding and use force only when it's necessary to defend yourself, to defend your colleague, and not use force sadistically or maliciously to cause harm, but use force as a means of restoring order. So Whitley versus Alberts, which of course was to restore order in the institution. Whitley was shot, survived, and sued, but he lost because the deliberate indifference standard was not used in the situation. The Supreme Court said that the lower court cannot second guess prison officials in decision who make split second decision to restore order. But in Johnson versus Glick, that's a different situation. Pretrial detainee who didn't pose any significant threat was assaulted by Johnson, and Johnson was found guilty of assault on the inmate. What I'm saying here is not to criticize any officer's action, because I'm not in the situation that the officer were in. One of the things you got to look at the totality of the situation. You got to look at the totality of the situation whenever you're making a decision. So, folks, my name is Pico Conway. This is our 4th episode of talking about CO issues. And as I said, I will describe issues. I will describe situation, events that might resemble something that happened in your institutions, but I'm not talking about this issue in particular. These are all hypothetical situations. But some of the cases I'm trying to use are cases that you can read. I'm only taking my points and my advice for correctional officers from these cases. My advice to you is, why it's true when we go to use of force training, we're told about these cases. It's good that you read these cases. Now there's these 2 cases, read multiple cases on the use of force. And you understand that the use of force should be only as the last resort and to restore order and not to harm anybody. First, my name is Pico Conway. This is our 4th edition of CO Issues. We'll come to you next week with another issue. Until next time, have a great day. Comment. And tell me if there's something I said in this video that you think was far removed from reality. We can make the correction. Until next time, stay safe And make sure you're following, you're reading your institution's use of force policy, and you're also reading the law as it relates to use of force. Whitley versus Abbott and Johnson versus Glade. There's just two cases, but there are many, many more cases on the use of force that you can read and get a better insight onto how and when to use force. Until next time, have a great day. I will talk to you when I talk to you. Bye for now.